back to Adam if he's able to join us. Just there for moving forward.
All right, this actually works out well because most of what I know about the subject I learned from Adam, and then Adam and I didn't compare notes and created presentations that cover a lot of the same ground. So the fact that he's not here, I'll just cover his ground for him, and that'll solve the duplication problem. As Ian mentioned, this is a very live issue here in the U.S. now because many states over the past couple of years have instituted these age verification laws for pornography websites. There's a number of, let's see here. Oh, sorry, this slide, this thing. There we go. Yep. Okay. Yeah. Okay. So I think there's about 23 different states at this point that have some kind of law like this on the books. There's minor differences between them. Texas is one of the most well-written laws, and the Texas law has now been challenged up to the Supreme Court. So this case is called Free Speech Coalition versus Paxton. So this certainly has the potential to be, probably will be, the most important obscenity law case in the U.S. since Ashcroft versus ACLU, which came before the court in 2002 and 2004. It is specifically assessing the constitutionality of this law, Texas HB 1181. So the history of the case is the district court initially enjoined against the law. So basically just said, you know, temporary injunction, this law cannot go into effect because there's concerns about it. Doesn't mean the law is necessarily voided and stricken down, but it temporarily is enjoined proceeding further, or pending further legal proceedings. The Fifth Circuit Court then earlier this year, so it was appealed up to Circuit Court. The Fifth Circuit Court vacated the injunction, said, actually, we think this law looks pretty sound, and so it can go ahead and go into effect pending further trial. Then the plaintiffs appealed, the Free Speech Coalition representing the pornography industry, and the Supreme Court granted certiorari and is going to be hearing the case this winter. So amicus briefs at this point are due November 22nd. So why is this case so important? As I noted, more than 20 states have now passed similar age verification laws. The Texas law is the first one that goes to the Supreme Court, and this ruling could very well determine the constitutionality of all of those laws and many future attempts to impose these common sense barriers on access to adult content. So it's also the first really big constitutional test for the concept of age verification since Ashcroft in 2004, which was assessing a federal law, a federal age verification requirement law. And the Supreme Court at that point deemed that law unduly restrictive. It believed that it would have a chilling effect on protected adult speech. It was too difficult for adults to have to go through this process of age verification. They might be afraid that their private identification would be leaked online, and so they would be hesitant to access this constitutionally protected material. The court said, absolutely, it's children really, like the court did not dispute that children should not have access to this material. All of the justices said, look, this is obviously not good for kids, but we need to find a way to prevent kids from accessing it in a way that doesn't meddle with First Amendment rights of adults. They also believed that age verification was likely to be less effective than content filters. Now, so that was all back in 2004. Now, a crucial issue here is the issue of scrutiny, what level of scrutiny the court applies. So back in Ashcroft, the court applied, this is actually not completely clear, and this is one thing that Adam Kandub is working on in his brief, but the court seemed to say that strict scrutiny needs to apply to that law in Ashcroft because this is a matter of limiting adults' protected speech. And so therefore it has to meet these, kind of jump these hurdles of showing that this is the least restrictive means, it's the most effective means. There's a very compelling government interest. The Fifth Circuit, however, ruled that in fact rational basis rather than strict scrutiny applies. And this is going back to a 1968 case regulating children's access to basically buying adult magazines at pornographic brick and mortar stores. And age verification was required for that. You had to show a driver's license or something. the Supreme Court said, look, this is a reasonable law. It easily meets the standard of rational basis. The stricter standard was applied for online age verification, and the question is, which is the proper standard to apply? So, going before the Supreme Court, they will not just be ruling on the, or potentially they might rule on the merits of the Texas law, or they might just rule on the question of what is the appropriate standard of scrutiny to apply. So I'm actually going to skip forward to this chart really quick. So this, as I best understand, I'm not an attorney, but this is my best understanding of the kind of different options before the court. In theory, they could do any of these different things. And the color coding is kind of red is the one that we least want to happen. The court goes ahead and strikes down the Texas statute. Now they could remember that this is just a preliminary injunction. So they could go ahead and say, you know what, we're going to go ahead and rule on the law. We're going to say the law is good and we uphold the law. We're going to say the law is bad and we're going to strike down the law. Or they could just say the law, it's a complicated enough question that it should go to a full trial, right? And so therefore we're going to uphold the injunction while the full trial proceeds. We're going to strike down the injunction while the full trial proceeds. And they could apply a strict scrutiny standard and say that the law actually meets that strict scrutiny standard. Or they could say, no, the Fifth Circuit was correct. The rational basis scrutiny is the appropriate level of scrutiny. And so it's not, therefore the law doesn't have to meet this very high burden of proof. So probably the most likely scenario here is that yellow one, where they might well say that the Fifth Circuit was wrong to apply rational basis scrutiny, and they'll send it back down to the Fifth Circuit and say, you need to evaluate this based on strict scrutiny, the way Ashcroft ruled. And then the case will continue. But we are hoping for one of the green or blue outcomes here. Now, whoops, there we go. So the legal objectives for the case, we kind of want to make arguments based on two fronts. One, there's a narrow argument, right, where we say, okay, let's assume for the sake of argument that strict scrutiny does in fact apply here, and that which is what the plaintiffs are saying. The plaintiffs are saying the Fifth Circuit got this wrong. The Fifth Circuit contradicted Ashcroft. This needs to go on strict scrutiny. And the plaintiffs think if it's on strict scrutiny, it will fail. We would want to argue, even on strict scrutiny, it succeeds because Ashcroft is simply out of date. The technology has changed. Filters are no longer sufficiently effective given technological changes, right? So one of Ashcroft's claims was content filters get the job done, right? Parents can regulate this. Looking at, just look the previous two presentations, if 73% of teenagers have viewed pornography, that doesn't mean 73% of parents want them to. Very small percent of parents want them to. That means almost 73% of content filtering regimes are failing, right? So filters are no longer sufficiently effective. A lot of that relates to the advent of the smartphone, which was just not envisioned at the time of Ashcroft. Second, age verification technology has improved. It's vastly improved. It's far more effective, far more anonymous than was available back at the time of Ashcroft, and therefore it is the least restrictive means at this point. It can be done quickly, cheaply, anonymously, and securely. But we also, while making that narrow argument and saying that this law should hold up on that basis, and that's going to be a really key set of technical arguments regarding some of the legal technicalities and also the nature of the technology, we also hope to use this case to make a much broader argument. The court was afraid in Ashcroft that age verification would have a chilling effect on adult speech. Well, we want to contend that Ashcroft has had a chilling effect on legislative speech. Legislatures for the last 20 years have felt their hands tied in addressing this epidemic of pornography because they're afraid they're going to fall afoul of the Supreme Court. So what we want to argue is that this content that we're talking about is obscene and therefore not even constitutionally protected. It doesn't qualify for First Amendment protection. We want to argue, in keeping the presentations you've already heard, that porn's harms have escalated to the point of demanding government action. And we want to argue that the rapidly changing technological environment demands that we have judicial restraint and legislative flexibility, right? So the court needs to take a back seat and say, look, it's not for us as the court to say, this is the best technology right now, therefore all laws must conform to this technology. Rather, the court needs to say, look, this is obviously a big problem. Legislatures need space to respond to rapidly changing technologies with rapidly developing technological solutions. And we want to kind of untie the hands of legislators to do that. So this is kind of the strategy that's being pursued in a lot of different amicus briefs that are being filed. I'm pleased to report that I believe when I checked this morning, there's 22 amicus briefs that I'm aware of that are being filed in support of the Texas law in this case, several others under consideration. And we're trying to make a whole range of different arguments, both kind of about the technology, about the kind of judicial precedents, about the separation of powers, about the harms of pornography. And so if anyone tuning into this is interested in being part of that amicus effort, I would really encourage you to reach out to me or one of my colleagues. I don't know if my email address is on this slide, but it's blittlejohn@eppc.org. So thank you.
Thank you, Brad. That's brilliant. It's really interesting what you got on screen here about this is not your grandpa's porn. When I gave evidence in the original case in the Austin federal court, the judge that was hearing the case, his benchmark for pornography was Last Tango in Paris. And the Assistant Attorney General said he said, this is the first and only time I'm ever going to say this to a federal judge, but you really need to go and watch some porn. Because he just could not get his head around some of the evidence in terms of what is actually available online. If you're using Last Tango in Paris, which I think was about 1971 as a film, as your benchmark for what's pornography, you're a long way off what you're looking at. So thank you very much. And that's really great. Three great introductions there to why this is really important, the effects it's having on children in the US and around the world, and the real importance of this case, which is a once in a generation. They kind of get to this question about once every 20 years or so. So we had, I think Ginsburg was like late 60s. We had Reno, which is in the 90s. We had Ashcroft in the early 2000s. This is going to be the case of the next 20 years or so, I would imagine. So it's a really important one. And when we put this briefing together, what I wanted to do as part of this briefing